I'm Eugene Korn. I'm a senior research fellow at Beit Morasha's Center for Ethics and Society, and I have the pleasure of moderating this session. This session will discuss the right of self-defense in 21st century warfare. Under conventional just war theory, a state is justified in using force in its self-defense. However, the introduction of human rights considerations to the laws of armed conflict and the accumulation of legal rules derived from human rights values has affected some of the issues surrounding the concept of state self-defense. Have these changes created incentives to aggressors of the ad bellum rules and transgressors of the in bello rules? Perhaps the case of the State of Israel and its legitimacy to self-defense can serve as an example in this discussion. We have two distinguished panelists to analyze these issues. Yishai Ber is professor of law and the former dean at the Radnitzer School of Interdisciplinary Center at Herzliya, Israel. He specializes both in taxation and the law of armed conflict. He's also a retired Major General in the Israel Defense Forces. Professor Ber holds a BA from Hebrew University, an MA from London School of Economics, and a PhD from Hebrew University. He was a member of the law faculty of Hebrew University for 23 years and was visiting scholar at both Harvard and NYU law schools. Major General Ber's military career began in 1974. He took part in the 1976 rescue operation in Entebbe, and he continued to serve in the IDF, rising through the ranks and combat commands until he commanded a paratroopers brigade as colonel in 1995 and the Edom Division as a brigadier general in 2000. He was also commander of IDF's brigade and division commanders courses. In 2002, he joined the IDF's general staff when he was appointed president of Israel's Military Court of Appeals and promoted to Major General. Major General Ber is married to Chagit, and he's the proud father of 6 children. Arthur Applbaum is professor of ethics and public policy at Harvard University. His work on legitimate political authority, civil and official disobedience, and role morality has appeared in journals such as Philosophy and Public Affairs, the Journal of American Medical Association, Harvard Law Review, and Ethics and Legal Theory. He's the author of Ethics for Adversaries, a book about the morality of roles in public and professional life. Professor Applbaum has written about the ethics of executioners and butlers and has consulted to the government about the ethics of spies. His recent articles include Legitimacy Without the Duty to Obey and Forcing a People to be Free. He has been a member of Harvard's Advisory Committee on Shareholder Responsibility and chairs the Ethics Advisory Board of a stem cell research foundation. From 2007 to 2009, he was acting director of the Edmund J. Safra Foundation for Ethics at Harvard. Professor Applbaum holds degrees from Princeton and Harvard. He was a Fulbright Scholar in Jerusalem, a Fellow in Ethics at Harvard, and Rockefeller Fellow at Princeton University's Center for Human Values. Each panelist has been asked to present for about 20 minutes, after which we will devote about 10 or 15 minutes to questions and answers from the audience. Professor Ber.
Thank you very much, Eugene, and thank you all. I'm very proud to be here since I'm familiar of the great contributions that Beit Morasha has upon and its effect upon the IDF, and I'm proud to take part of this project. May I start with a personal note? I'm a lawyer, but what brought me to this field of international law is my capacity as a general. For the last 5 years, I was a corps commander. The Israeli military has 2 corps, so I was in charge of mainly, or generally speaking, of the Israeli army. And my core position, or main object, was the Lebanese front. I have started to learn the intelligence, and then I've started to learn the law. And then I became frustrated. I do know that it's not common to bring one's trauma to the podium. It is much cheaper than go to the shrink, of course, but it is indeed my own trauma and my own experience. The current legal rules prevailing under current international law, when it comes to law-abiding states, wants to obey the law and to keep their moral values, and specifically when they are fighting non-law-abiding either states or militia groups, we are currently out of balance. And so my main argument in this short presentation would be to present how far we are from proper balance in this segment of the law. The current rules, may I present them very briefly. The current rules of international law are divided into two segments. The first segment is the ad bellum rules, namely when wars are allowed or when states are allowed to use military force. And the other segment of the law is what is called in bello, namely how states are allowed or how militaries are allowed to fight. The first segment is currently governed by the UN Charter. In the UN Charter, following its precedents, the League of Nations, and the Koch-Briand Pact, if you may, the President Wilson legacy, has declared that military force is not allowed anymore. Namely, states are not allowed to use military force proactively. This is the current UN Charter. It has two exceptions. One, self-defense. The other exception is when there is the authority of the Security Council. Since the Security Council is an impotent body, so there is one exception, the Korean War, and to a lesser extent the Iraqi case, but by and large, since the Security Council doesn't function, we are having only one main exception to the prohibition, which is self-defense. The problem is that the limits or the current self-defense exception is very limited. It may apply only when armed attack occurs. That means, for example, that any humanitarian intervention is not legal, legally speaking. So take the case of Syria. Nowadays, more than 30,000 people have been murdered. But China and Russia are absolutely correct when stating that humanitarian intervention is out of question, legally speaking. Of course, not morally. The moral perspective is is totally different in this case. When it comes to the in bello rules, the main two rules which makes a lot of sense, of course, are the distinction rule, namely civilians are out of the game or the war game. It was Clausewitz who said 200 years ago that states fight. It has, according to Clausewitz theory, the people and the military fight. But since the 19th century, the international community has adapted the idea that civilians should be spared, and so we are now having the distinction rule. And then the proportionality, which if I will have time, I will consider that. So this is a basic contour of the prevailing legal rules. The main problem is that it just doesn't work. Let's start with the ad bellum section or part of the law, namely the prohibition not to use proactively military force. The UN has been founded in 1945 after the San Francisco Conference. It took 25 years to the late Professor Thomas Frank of NYU to issue an interim balance of the record of the UN, and I quote, "In the 25 years since the San Francisco Conference, there have been some 100 separate outbreaks of hostility between states." And then Professor Frank concludes, "The prohibition against the use of force in relation between states has been eroded beyond recognition." It took another 35 years towards the end of the millennia when another professor made his own empirical experiment. He checks the data, he checks the data, and then he presents his own normative argument. And now I'm quoting from a different paper now by Professor Glennon. and I quote, international rules concerning the use of force are no longer regarded as obligatory by states. Between 1945 and 1999, 2/3 of the members of the United Nations fought 299 conflicts in which over 22 million people were killed. This series of conflict was capped by the Kosovo campaign in which NATO violated the charter. The international system has come to succeed in a parallel universe of two systems. One is the jure, the other de facto. The de jure system consists of illusory rules that govern the use of force among states in a platonic world, a world that does not exist. The de facto system consists of actual state practice in the real world, a world in which states recourse against benefits. So we are having two universes. And may I have only another one quote, one sentence from the great scholar Michael Walzer is sitting here. And Michael Walzer in his book writes that lawyers have constructed a paper world which fails at crucial points to correspond to the world the rest of us still live in. May I demonstrate it by only an example? When Russia invaded Hungary in the 50s and Czechoslovakia in the 60s, it legally justified its own activity, namely the invasion, the fighting against people who rebelled in order to gain their freedom. The justification for the invasion of Hungary and Czechoslovakia by the Soviet bloc was self-defense, collective self-defense under the Warsaw Pact. This is the world, or the gap between rhetoric and practice, the gap between the real world and the lawyer's world. But may I go further? And I would like to point at some incentives, and I do mean incentive, given to aggressors and transgressors currently under the prevailing rules. And I will point, due to the short limit of time which I have, upon 5 segments of such incentives, or 5 different types of incentives. Most of them are justified per se. They are rules, or rules of the law of armed conflict and the law of war, which are justified, most of them are justified per se. But when we are looking at them as a whole, the bottom line is a distorted reality in which there is incentive, or there are great incentive to breach the law rather than to keep it, incentives to aggressor and transgressor, and this is the world in which we live in. The first incentive. Under the prevailing rules, there is a total separation between the ad bellum segment of the law and the in bello. The mere fact that state A invaded state B doesn't have any connection whatsoever to the treatment in which the soldiers of state A and B are entitled to. Both entitled the same benefits. Of course, the leading example in the literature is that the German who invaded Poland in September 1, 1930, September 1st, 1939, the Wehrmacht soldier enjoys the same benefits as do the Pole soldier. The Allies in the 40s who fought against the Nazi apparatus against the Wehrmacht enjoys the same legal treatment. Of course, to some extent, it's against our basic intuition. It has, it should be, I think it has, moral philosophers do argue whether it's correct or not. The vast majority of them think that it's a good rule, and I do think that they are right. May I mention only 2 points? First of all, it's very difficult. I brought, of course, the Hitler's, the Nazi example, the Germans' invasion to Poland, but in most cases, when 2 states fight each other, everyone justifies itself with arguing that it has its own legitimacy. So it's very difficult to say when we don't have a proper judge or who can manage, who is just, whose wars is just. So it makes sense to have the same rules to all participants. Furthermore, when you think about the reciprocal consideration, it makes a lot of sense to deter the German soldiers, when they are fighting the Allied soldiers, that they have to treat the prisoner of war, the wounded soldiers of the adversary, etc., in a similar treatment, so it gives them incentive to play by the rule. But the bottom line is that when an aggressor decides to attack, he knows for sure that his soldiers won't be punished for that. Whether he, the leader, will be punished, let's talk about it in a few minutes. I can tell you the secret, he won't be punished. The leader won't be punished either. But the soldiers of the aggressor are not punished whatsoever. So here you have the first incentive to aggressors. And here comes the second. In fact, there are no punitive tools, actual punitive tools. There is no punishment against aggressors in the current world. May I give a few examples? In the old days, reprisal was very effective. You breached the law, reprisal will put you in place. We shall revenge. So if you cross the red line, we shall cross the red line too. But now the mere fact that you are a criminal doesn't justify, according to the rule, any reprisal from my own side. So reprisal, which is very deterring, has very deterring effect, is not relevant anymore, is not legal. A second example. In the old days, there were territorial prizes. If an aggressor attacked a defended state, and then he lost territory, he lost territory. He is being punished. Nowadays, territories are not asset anymore. If we are having CPAs here, it becomes a liability. Look at the case of Israel with the occupied territories. Look at the case of the United States vis-à-vis Iraq. The minute you conquer territories, you have so many obligations vis-à-vis the local domestic citizens, and at the end of the day, you are obliged to return the territories. So this has also some kind of an incentive to the aggressor. He won't lose anything. A third example from this type of arguments, monetary or financial compensation. It makes a lot of sense to impose financial sanctions vis-à-vis the aggressors. But at the end of the day, in most cases, they are not effective. Think about the Versailles Pact and the effects of the compensation imposed upon Germany after World War I, and what effect it had upon the Third Reich. Hitler leveraged and manipulated the story of this compensation in order to come to power. Maybe there is an exception in the case of Saddam Hussein, which had to pay compensation, but this is a unique example because it brings to the, it is an example of a dictator who has budget or financial resources of his own. But this is not the typical case. So by and large, I can say that there are no actual punitive tools against aggressors. You are abided by the law, he doesn't obey the rules, you have to play by the rules, he doesn't. The third example, which I would like to present, is a modern trend which is prevailing currently by judges, respected professors, the legal community, substantial part of the legal community, and this relates to the ad bellum proportionality. If aggressors attack a state, the defendant state is entitled to defend itself. That's the meaning, that's the essence of the self-defense. But to what are the limits upon its reaction? Now, the current trend is to say that the defendant state has to act proportionality, in a proportional way. The late Thomas Frank said you have to act equally, in a similar manner. So it's almost a win-win situation. Aggressor attack, if he wins, he wins. If he is losing, the maximum reaction that he might suffer is similar to the, or equivalent to the amount of force that he has used. No deterrence whatsoever. The force incentive to the aggressors and transgressors is a confusion between human rights law and the law of armed conflict. The mere introduction or the mere introducing of human rights ideas to the law of armed conflict should be endorsed. You have to treat your adversaries civilians, your adversaries wounded soldiers in a humanitarian way. This makes a lot of sense. כי בצלם אלוהים ברא את האדם. God has created all of us in his own nature, in his own image. Okay. Even your adversary. So it makes a lot of sense to introduce human rights idea to the law of armed conflict. But at the end of the day, there are limits to it. Because war is about fighting for the sake of one's own self-defense. Unfortunately, in war, the name of the game is to kill in order not to be killed. And I can bring one example, a distorted one, from the Goldstone report. But there are many, many examples. And the example relates to the human shield phenomenon and specific technique adapted by the IDF called knocking on the roof. The human shield phenomenon is not new. It happened in Kosovo, for example. Volunteer Yugoslavian gathered on the bridges of Belgrade in order to shield them against NATO's bombardment in 1991. In Iraq, for example, Saddam Hussein used his own people in order to shield his own military assets. When it comes to the Middle East, both Hamas and Hezbollah used it in order to protect their military assets. Under the current prevailing rules, according to the additional protocol of the Geneva Convention, there is a requirement of early warning. It makes a lot of sense. In order to, you have to warn the other side adversary to get out of the arena in order that they won't be killed. They are innocent at the end of the day. But according to the protocol, to the Geneva Convention protocol, this is not a mandatory, but rather it's a contingent obligation. It depends upon the circumstances. So NATO, for example, in the Kosovo campaign, has declared that they are not accepting the early warning requirement. It's not a mandatory one. They want to not to risk their own pilots, so they won't disclose when and where they are going to attack. Israel, in order to spare innocent civilians, adopted a more conservative approach, the early warning. So the technique used in the campaign 3 years ago in Gaza was to call, use the telephones, the cellular phones, to call local residents, and they give them 10 minutes warning, early warning. Please get out of this specific building. We do know that there is ammunition in this building, or there are rockets. Get out of here, and then you spare lives. What happened, since Hamas knew that if our pilots would recognize that there are civilians still in the building, they won't shoot, they won't fire. So the Palestinians reacted by gathering their own civilians on the roof. It is different and total question what's the status of those guys who gathered in the roof if they come voluntarily. If they were imposed, it's of course they are innocent civilian. If they came, if they volunteered to come over there, it's a very interesting question. They put moral challenge, of course, to our pilots. But let's put it aside. Israel adopted a unique system, very expensive one, which doesn't have any parallel in other militaries. Israel, the Air Force has invented a very sophisticated missile, the same missiles, very precise guided ammunition, very sophisticated missiles, which can hit the roof by inches. They can hit the corner of the roof. They don't have explosive, but rather cement as a warhead. And the aim of such missiles is, of course, to frighten those gathered in the roof in order to enforce them to get out, and then when they will, you see, 5 minutes recommendation. By Israeli standards, it's a recommendation, you know. We should not bargain, you know. Okay, that's fine. Okay, what Israel did is to fire such a rocket, which its warhead consists of cement, in order to frighten all those people gathered in the roof, and then when they will go away, then to fire the real missile and to hit the target. This is an adventure which has a few derived consequences. First, you risk your pilots and your soldiers because it takes a while, all this process. May I remind you that NATO was not willing to risk its own America. The USA was not willing to risk its own pilots. Israel did risk its own soldiers in order to complete this process. Second, it costs fortunes because every missile, all those missiles, the real ones and the faked ones, the one with the cement warheads, cost the same, the electronic cost, not the explosive. When I'm speaking about fortune, we are speaking about hundreds of millions of dollars. So Israel should be praised for that, isn't it? Now I will read a paragraph from the Goldstone report. What does the Goldstone report has to say about this technique? And I bring it as example how human rights lawyers bring to absurdum the law of armed conflict. And I quote, the legal requirement, remember the contingent legal requirement, they don't mention the fact that it's contingent, it's not mandatory, but okay. The legal requirement is for an effective warning to be given. This means that it should not require civilians to guess the meaning of the warning. The technique of using small explosive to frighten civilians into evacuation, even if it is intended to warn, may cause terror and confuse the affected civilian. And then, may I read another sentence? The mission does not consider the technique of firing missile into or on top of buildings as capable of being described as a warning, much less as an effective warning. It is a dangerous practice and in essence constitutes a form of attack rather than a warning. How much hypocrisy can be injected into two sentences? Israel risks its own soldiers. Israel invested millions, hundreds of millions of dollars in order to spare innocent civilians. Of course it's frightened, but this is war. What is the alternative? My best friend, Moshe Halbetal, who is sitting with us, wrote a great piece in the New Republic answering the Goldstone, or relating to the Goldstone report. With your permission, Moshe, we have some business to settle currently. I read one sentence. It is rather, and a quote from Moshe Halbetal's piece, printed from the New Republic, it is a rather strange point in the Goldstone report that this practice, namely the procedure of the roof knocking, which goes a long way to protect civilians, is actually criticized. When I read, Moshe gave me to read the draft, and I read only critic in real time. I told him, Moshe, what language are you speaking? You have to write that it is hypocrisy, that they don't understand the reality in which they are talking about. If the alternative is to kill civilians, it makes a lot of sense to frighten them rather than to kill them, because it is legal to kill them. The NATO bombers did kill without early warning. Israel preferred to warn them, indeed to terrify them, in order that they will go away, rather than to kill them. So Moshe Halbetal writes, it is rather a strange point. So I told him, you have to write the truth, namely it's the mission doesn't understand, the Goldstone report doesn't understand what it talks about, or they are hypocrites. So he told me, you know, Yishai, in the States, they are talking in a different manner. Understatement is preferred way of expression. Now, Moshe, it's my time to revenge. And I talk the truth, and I tell the truth. This way of expression of introducing absurd human rights way of thinking. Namely, it's not fair to frighten citizens, of course. If the New York Police Department will frighten me by knocking on my roof or by knocking on my door, it's not acceptable. But if the alternative in wartime is to kill, it's much better to frighten than to kill. But the Goldstone report blamed Israel for frightening innocent civilians, forgetting that the alternative was the legal, strictly kosher alternative was to kill them. Unacceptable. Fifth incentive is the too much lenient approach towards leaders. You can be an aggressor and transgressor, and at the end of the day, you don't pay the bill. You don't pay the bill. Look what currently happens in Syria. Indeed, there are a few exceptions. The Nuremberg trials, the Rwanda cases, the Yugoslavia cases, currently the ICC established under the Rome Statute. There is international court, but you know what? There is no definition for the crime of aggression. And since there is no definition for the crime of aggression, you cannot bring aggressor to justice. This is the reality, this is today's reality. So there is an unacceptable, lenient approach towards criminals. I'm talking about criminals, leaders. So all these 5 components, which I've described very briefly, I'm afraid from the chairman, create an unacceptable package for incentive of aggressor and transgressor. What should be done? I don't have time for that, but may I give 2 clues about potential directions. First, leaders' responsibility. When I mean leaders' responsibility, not only ex post, but in real time. And there is a special session today about targeted killing. Think about the following names: Hitler, Muammar Gaddafi, Saddam Hussein, Bashar al-Assad. How many people are killed, were killed, are going to be killed due to such tyrants and dictators prevailing currently or governing their own state? And the targeting killing has substantial moral advantage, which there is a separate session today which will be discussed. Another dimension which should be promoted is, with all due respect to lawyers and to the lawyers' world, as Michael Walzer put it, I think that lawyers have done the best. I mean, the legal documentation, the rules, the prevailing rules are there. They present a compromise. Unfortunately, a bad compromise, which I've just presented its failures. So it's now time to professional militaries, professional soldiers to step in, to moral philosophers to instruct them. I think the ethical values and norms are much more challenging than the legal rules. And I didn't have time to speak about the other segment of the distinction rule, the fact that soldier can be killed for the sake of the killing currently under the legal rules. Soldiers' blood is the cheapest commodity in the war game. There is a necessity principle under current international law, but even according to the Red Cross, it doesn't have any actual meaning whatsoever. Because at the end of the day, what might be challenged, militaries, and I mean militaries of Western democratic liberal states, is introducing more and more ethical values to the war zone. And in short, this is what this conference is all about in general. And we're talking about Beit Morasha in particular. This is the value added of the Beit Morasha to the IDF. Thank you very much.
I completely agree with Yishai's description of the situation. I think that the current laws of war and human rights laws are asymmetrically unfair in the sense that they give advantages to aggressors and to human rights violators. My conclusion is different. My conclusion is, well, it's unfair, and one of the burdens that we have to bear to support the humanity of others and to respect our own humanity is simply to assume at least some of those burdens. In fact, my conclusion will be that the nature of 21st century war and the asymmetries of 21st century war may in fact call for more protections of civilian populations than is standardly the case rather than less. Here's what I'm going to do, and I'll try to do it as quickly as I can. I'd like to build, I'm a philosopher, I like to analyze and build things up from little building blocks. I'm going to start by asking, well, if our topic is what's the right of self-defense in military conflicts in the 21st century, first, what's the right of self-defense in military conflicts? But before that, we have to ask about what's the right of self-defense at all. So I'm going to build up from just the basic ordinary moral intuitions about self-defense, add in whether war makes a difference, and then at the end add in whether or not the 21st century makes a difference. Okay, so what is the right of self-defense? Abstract away legal situations if abstraction is not something that comes easily to you. Imagine that we're living under laws, but the laws of no avail right now. Someone's attacking us, and the police officers are not here. They can't help us. So what's the basic setup of self-defense? The basic setup of self-defense is attacker A is to kill defender D. To kill defender D wrongfully, right? If it turns out that attacker A is a duly authorized police officer and defender D is a criminal who's threatening somebody else, then it's not a question of self-defense, right? So wrongfully. And we say imminently, right? If defender D has other easy alternatives, then self-defense can be avoided. When that's the case, then D prevents the killing of himself, D, by killing A. And of course, self-defense is not just for oneself, but one could also defend others under the same principle. Or it could be a C who prevents killing of D by killing A. Now, what are the justifications, ordinary moral justifications for self-defense? Well, it's not an unlimited right of self-preservation. I think we could all admit that, right? There are certain things that Yahareg va'al ya'avor, you should be killed rather than transgress. I think examples come to mind rather quickly. You can't kill the entire city in order to prevent yourself from being killed. So it doesn't come from an unlimited right of self-preservation. It's not that the attacker forfeits all rights, because once you've disarmed the attacker, you can't then go on to kill the attacker, right? Your rights against the attacker are rather limited. The justification of self-defense is not punishment of the guilty. The attacker, in fact, may not, in fact, be guilty, and I'll give you some examples of that in a moment. Rather, the right of self-defense is fairly limited. It's the right to prevent the violation of one's own rights to personal integrity and external freedom, subject to certain constraints. The obvious constraints being that you can't thereby violate other people's rights to personal integrity and external freedom. To see some of the limitations, let's use some examples from bystanders. So suppose the setup is that the only way you can prevent A from attacking you, your D, the defender, is, it turns out there's an innocent bystander who's standing on a bridge, and if you shoot the innocent bystander's body will fall on the aggressor, on the attacker, and thereby save your life. I think straightforwardly you can't do that. You can't use an innocent bystander in that way and aim at his death in order to save yourself. This is a case of Yahareg va'al ya'avor. You should be killed rather than killed, because the right of self-preservation is not unlimited. What if the defender grabs B as the bystander as a shield, so that A shoots into B rather than into D? No, you can't take another person and threaten another person in that way and use another person as a shield. I think that's straightforward. What about if you duck and the bullet goes over your head and hits B? Oh, that's a little more complicated. Probably you can duck, right? Because you're not seeking out B's death. You're not using D. These are things we can spend hours talking about these, but I want you to see the complexity of just ordinary moral self-defense before we even introduce war. What if D deflects the path of A's projectile onto the bystander B? Oh, maybe. What if D targets A, foreseeing that nearby B will also die? Collateral damage. Yes, we understand that within certain limits that is permissible. Again, because you're not using B for your purposes. You're not violating B's rights for your purposes. But then, of course, there are considerations of proportionality. Suppose that the only way you're being attacked by 100 A's, and the only way to defend yourself is by killing all 100. Well, yes, of course you can. It's not as if each Each of the 100 is actually attempting to violate your rights. Each one is a rights violator, and you could defend yourself against all 100, right? What about killing 100 A's when killing 10 A's would be sufficient? Well, there I think it's straightforward that you can't. If you can equally effectively kill only 10 of your attackers, you can't kill all 100. Remember, self-defense is not an entitlement to punish. It's not an entitlement to go after the guilty. It's not an unrestricted right to self-preservation. Similarly, what if you can effectively defend yourself by warning away the attacker, or by wounding the attacker, or the laws in Florida about stand your ground notwithstanding, by retreating from the attacker? Well, I think ordinarily one would conclude that, no, you have to take these lesser means. Again, if the probabilities of defending yourself are equally the same. What if A attacks you, for sure, but he only has a 10% probability of success? Well, then, yes, I think rather clearly you can defend yourself. He is attempting 100% to violate your rights. But what if instead you actually don't know if A is an attacker or not? There's only a 10% probability that A is an attacker. Then I think it's rather straightforward that you can't attack A in the off chance that maybe A is an attacker. What if, again, proportionality, what if D kills A foreseeing that the collateral damage will be 100 non-threatening bystanders? Again, we can argue about proportions. There's no algorithm for this. But it seems as if this is excessive. Your blood isn't redder, as the Talmud says, right? What if, in order to save 100 Ds, you have to directly kill one of the Ds? Now we get into this area of deep, deep moral perplexity. Right? This is an interesting and hard question. What if instead of killing one of the people who is already targeted, it's an innocent bystander who you kill? This is rather tougher, right? Arguably, you're not justified in killing one bystander who is not under threat in order to save yourself and many of yourselves. We can argue about some of these, but the structure of this, I think, is rather clear. The right of self-defense is not unlimited because there is no unlimited right of self-preservation. There are limitations. There are limitations that are burdensome. There are limitations that actually involve you accepting serious burdens, including death, rather than defending yourself. The justification of self-defense does not depend on the culpability of the attacker. The attacker may in fact be mistaken, may think that you're an attacker, mistakenly, right, and perhaps reasonably. A may be coerced into it, or maybe, in the war case, may be conscripted. A may be insane. A may be a child. Maybe A's brain is controlled by an evil neurologist who's propelling A towards you to attack you. Maybe, in fact, A isn't taking an action at all. Maybe A's body is simply being used as a lethal projectile. I think it doesn't matter whether A is guilty or innocent. It matters whether A is a threat. And that's all that matters, okay? So, when D may harm A, it's not because A is guilty, bad, or an outlaw, in the sense unprotected by the laws because of something that he's done. It's simply that he is liable, not culpable, and he loses his immunity. It's not because he isn't innocent. Now, this is true not just about A, but it's also true about the bystanders B. When you are permitted to harm a bystander as some kind of collateral damage, it's not because the bystander is guilty, bad, or an outlaw. It's not because of the bystander's political affinities. It's not because the bystander is actually rooting for the attacker. None of this actually morally matters. It's only when you may harm B, it's because B has lost his immunity, not because he's lost his innocence, and because he is liable, not because he is, in fact, culpable. Okay. How does moving the idea of self-defense into the idea of military conflict change things? Okay. Well, we might think that war is a morality-free zone, or we might think that it's a rule-governed practice. Now notice, you can't hold both of these two things consistently. And Michael Walzer has eloquently written better than anyone else why it is that we must not think of war as a morality-free zone. I mean, even if the actual attackers are ones who, contrary to what I said, are ones who have forfeited their claims under morality. It's certainly not the case that everyone around them has, right? So it is not a Hobbesian state of war of all against all, but rather it is in fact a rule-governed enterprise. Maybe it's the scale that matters. War, of course, is very large. It's not simply these one-on-one examples of 1A and 1D. It could be that war typically, or at least 20th or 19th century war involves states, and maybe the fact that states are involved is what makes a difference. Let's start with rules. Of course, we've already been introduced to jus ad bellum and jus in bello, and also the reason why it is that we ordinarily don't hold at least low-ranking soldiers accountable for the reasons for going to war. Ordinarily, it's unreasonable to hold them accountable because it's a rather difficult calculation, and you mentioned quite rightly the incentives and the reciprocity. So we want to modify our account of what triggers self-defense. It's not that A wrongfully attacks D, but it's simply when A attacks D. We don't make judgments of whether the attack is wrongful. You may, in fact, be on the wrong side of things in the jus ad bellum situation, but still you're entitled to self-defense. Okay. At least one side is always unjustified in a war, and rules can't make war symmetrically fair, like a sporting match can. So the analogies to fair fights in sport really do run out. It's rather we act as if there are symmetrical rules because we don't hold enemy soldiers accountable for their leaders' purposes, and because we want reciprocity for the treatment of our own soldiers. Okay, how does scale matter? Well, war is an ongoing project. It's not a discrete action. Hobbes very famously says, war is a condition like foul weather. He's talking about England, right? So we have to do a modification. A imminently attacking B, we have to drop that idea and introduce something else. A has undertaken the project of attacking D. And if A has undertaken the project of attacking D, then effective defense of D sometimes requires undertaking an offensive project against A, right? So we see how in the military situation, things are scaling up. There's another important aspect of scale, which is war is a group project. I'm going to spend some time on this idea of war as a group project, not an individual action. So we modify A attacks D into this. A is part of a group of A's attacking a group of D's, one of which is D. Okay. And again, an effective defense of group D requires undertaking an offensive project against group A. Okay, so there are limits to self-defense in the military context as well. If war is a group project, a more expansive specification of threat is justified, but as of course we've seen, still there is the discrimination between threats and non-threats is important, and some version of proportionality as well is important. Let's go back to this idea of a group, because we need to understand now what constitutes a group for these purposes and how being a member of a threatening group actually might change things. Now, I actually believe, somewhat controversially, that there are things called group agents. I don't mean anything spooky or metaphysical. It's not group minds or group brains or things like that. It's just that there are certain conditions under which a number of us together can be said to act together, and therefore we together can claim rights, not in virtue of this groupiness, because there's no metaphysical entity there, but in virtue of the individual rights that we have. And we could be held to account. We can be responsible for our group action, even if any individual of us has not particularly acted. And I think that this is the case because if we think about what a moral agent is, I can offer conditions for what a moral agent is without actually referring to the wet thing between our ears, referring to an actual psychology. A moral agent is an entity that can consider and can will and can act based on its considerations and its decisions to will. And since nothing there made reference to psychology or to brains, you could imagine groups of people functionally doing this thing called considering, willing, and doing. Okay? I think groups can sometimes pull that off. Corporations under law pull that off. Clubs and associations pull that off. And the largest example of a functioning group agent that we know about is the state and its citizens, where because of the kinds of procedures that it has and the ways in which people are meshed together, you can say that a state is a group agent. Now, there are two kinds of groups, and this is actually going to be important to our 21st century war situation. We can think of groups just in our ordinary parlance. Groups are people who have certain kinds of affinities, common sentiments, religion, language, they have feelings of solidarity. That's not the kind of group that I'm talking about that has significance. Okay? So yes, Judaism is a group in a certain sense, but no, Judaism does not have a way of collectively rendering decisions for action that hold us all to account, at least not nowadays, right? A normative group is something very particular, right? It's an entity that has the capacity to act as a shared agent, that itself is the proximate locus of moral responsibility and respect, and that is capable of wronging and being wronged, right? It can do that because it functions as an agent in the sense that it's able to consider, right, and to will and to act. Because of a complicated connection between it and its members, obligations and duties to the members can sometimes be discharged by discharging your obligation to the group. The actions of its members can sometimes make the group accountable, even though the group itself didn't. So, and I think that when we understand, by the analogy to corporations, we see how this works, right? So an engineer manufactures, designs a negligent car, and the shareholders pay the price. The shareholders aren't culpable, they've done nothing wrong, they haven't acted negligently, right? But we understand that for purposes of who pays the price, the shareholders pay the price because they're members of this normative group. I will skip how it is that groups become groups. Oh, that was so interesting. Legitimate states are a kind of normative group. They're a kind of normative group that are put together, that are constituted by shared procedures like constitutions, right? And members, citizens, or subjects are conscripted to that group by what Kant calls practical necessity, right? They really, rationality requires that they hang together in this way because it's the only way in which they can provide for their rational or necessary ends, to put it very briefly. Now, states have a more inclusive right, in part because of the way in which it is a normative group. They have rights not only to bodily integrity and personal freedom, but also to territorial integrity and political freedom. But here's what gets a little tricky. They also have a more inclusive liability, because there is a sense in which, when you have a functioning normative group, of which I'm holding up a legitimate state as an example, there's a sense in which you can hold individuals of that group accountable in some measure, in some way, for the actions of the group, by analogy to holding shareholders of a corporation accountable in some way for the negligent actions of a corporation's engineers. Do you see where I'm going? Okay. 21st century warfare. How is it different? Well, it's different in at least three ways, and Yishai has mentioned, has touched on all these. One is that there are unilateral violations of the rules of war by non-state group agents, right? And there's quite a bit of ambiguity about who the individuals are who are posing the threats. Okay, let's take this one by one. Unilateral violations of rules of war. How are we supposed to think about that? I think the way to do it is we revert back to the basic self-defense case, where A wrongfully attacks D, but we just simply have to go back to the moral case, where we already concluded there's no unlimited right of self-preservation. The attacker does not forfeit all rights, and self-defense is not punishment of the guilty. So what if someone is attacking me in violation of the rules of war? That simply puts us back to the original immoral case of someone is trying to violate my basic rights. I can defend myself, right? But not in an unlimited way. The attacker doesn't forfeit all rights, and the attacker is not to be punished by my counterattack, but punished in some other way. No, it's not fair. It's not fair. But that doesn't mean that morality doesn't require that of us. Attacks by non-state group agents. So attackers may constitute a normative group. You may have a group of terrorists, you may have a militia, you may have an insurgency and a guerrilla group, but the normative group that the attackers constitute not only does not but cannot act for the wider anthropological group. Note this well. This is one of the ways, perhaps unfair, Yishai, this is one of the ways in which civilians who are anthropologically, sociologically connected to the attackers get a bit of a moral free ride. Because unlike in states where, again, in some measure, citizens can be held to account for the actions of its government, With non-state actors, there's no there there. When there is not, the there is not the anthropological group, which of course is there, but there is no normative group. Guerrilla groups are not properly constituted to personate or represent or speak for the people they say they are fighting on behalf of. And so we encounter individual non-threatening civilians as we encounter individuals in a state of nature. Our obligations are to them directly, not through any entity that speaks for them. Leaders of an illegitimate government may constitute a normative group, a group of thugs, a kleptocracy, who can be held accountable for each other's acts, but they they cannot act for the country's inhabitants. I don't even want to call them citizens because they may not even be citizens. Again, this is unfair, right? Because some of these citizens support the kleptocracy, right? Or some of the members of the anthropological group are cheering on the terrorists. Doesn't matter. Doesn't matter. They are not threats. And if they are not threats, they are not liable to actions of self-defense. So there are serious limitations on individual liability that follow from this idea that these non-state actors are not, in my parlance, normative groups. Ambiguity of individual threats, absolutely there. They don't wear uniforms. It's unclear who's part. These threatening normative groups don't have membership lists. They may be getting material support in ways that we can't observe, right? But still, I don't think this leads to any less protection of the civilian population. And in fact, it may lead to more for reasons that I've already explained. We confront civilians who may with some probability be also threats, but we don't know. We confront them like we confront individual people in a state of nature. We can't discharge our moral obligations towards them by treating their group in a certain way. Right? We can't hold them accountable for the actions of a group that they are not, normatively speaking, a member of. Okay? Our moral relationship with individual civilians is unmediated by any legitimate government if we're in this 21st century situation where we're dealing with non-state actors or illegitimate governments. And so I conclude, not reluctantly but wistfully, because I certainly understand, Yishai, the horrible dilemmas and burdens and really deep sense of unfairness that you've described, that not only does 21st century war not give us greater moral permission to engage in collateral damage, so to speak, of civilian populations, but in some, at least in one respect, it actually tightens up these requirements. Thank you.
So we'll take some questions from the floor for approximately 10 minutes. Yes. Fred?
General Bear, thank you very much. I thought there was an amazing juxtaposition between your two thoughts. I'll try to brief my question. Could you talk about the issue that in the 21st century, unlike the 20th century, wars increasingly are not between states, but the laws of war are designed for how the states will place each other in a situation of war.
Indeed, we are talking about asymmetric wars. Asymmetric in a sense that states are fighting non-state groups. I think what we have to do when we look forward to the next century is to keep the core values, what I think is ethical values, basic intuition, that innocent civilians should be spared. I mean, let's take the case of Israel. And I've spoken about my own trauma vis-a-vis the Lebanese front. I think Israel should do whatever it can in order not to kill, in order not to damage innocent civilians of its adversary. But if one really wants to protect innocent civilians, there should be some other tools available to the defendant military, whether it's the American vis-a-vis Al-Qaeda or the Israelis vis-a-vis Hamas or Hezbollah. And what are those tools? For example, targeted killing of whom? Of the leaders who conducted all those atrocities. Of course, talking about, for example, about targeted killing is extrajudicial assassination. which is quite common and fancy expression of what's going on. When you talk about bin Laden, or when you talk about, in Israeli reality, about the Hamas leaders of Hezbollah, they are instructing their own people to fire rockets. They are so-called commander-in-chief of their own terrorist groups. So they ought to pay the price. I mean, the international community cannot enjoy, let's say, the Red Cross currently, in his opinion, say, we are fully aware of the phenomenon known as the evolving door, namely, part-time terrorists. You are a farmer in the day, in the night you fire rockets, but then you wear your set of jeans or whatever, if it's a three-piece suit, that's fine. You are a civilian. That's the current approach of the Red Cross. This is not acceptable. If you are a terrorist in the night, you are a terrorist, and an army that wants to defend itself can treat you as a target. If you want to spare civilians, you have to pay in some other coins. And I think leaders' responsibility is one of the typical direction which we should go ahead and legitimize it. Thank you.
One of the things that seemed to have been missing from his analysis was the sort of moral safety of the individual soldier. I think it was you who mentioned that they're the ones who have the least in terms of moral status, the one who is attacked, D, and all of the comments about the warfare being unfair in order to be moral tends to sort of leave the defender in a very open and vulnerable spot. And I was going to sort of ask him, and I'll ask you, what about the sort of the right of survival or the right to sort of to live for the defender, despite the unfair nature of the attack and the situations that that Professor Applbaum put forward? It seems that one ends up becoming a victim, a double victim, one by virtue of being attacked, and two by the fact that you have to make a decision to allow yourself to be killed even though you are wrongfully attacked by others. And he sort of seemed to have left that part of the equation out.
Of course, I can only respond on my behalf, not on Professor Applebaum's. And I am not a philosopher, I have to admit. The mere fact that you are a soldier, you know, to be a soldier, it's quite a risky occupation. It's not a Jewish profession. But, you know, in Israel, we are soldiers due to the fact that we don't have alternative. First, moral obligation to defend our state, and besides, you know, it's mandatory service in the Israeli army, even nowadays. So the mere fact that you are a soldier put you in risks. That's by definition. Professor Asa Kasher, as a gender, and I'm sure that he will talk about it, that if you are in the military, like in Israel, where it's mandatory service, it's put you to some extent in a different position than professional soldier. But this I leave to Asa, and I'm sure that he will talk about that. But remember the other side of the story. Indeed, the Israeli soldiers who are defendant are currently under risks, but remember the other side, the innocent civilians of the adversary. And I do agree with Professor Waltzer's argument in his book that in order to be entitled to the collateral damage, so-called privilege, which allows you at the end of the day not to intend to kill the civilians, the innocent civilians of the adversary, but if you have done it unintentionally, you are still right as long as the military gain achieved is substantial. But even then, you have to some extent to risk yourself in order not to kill too many innocent civilians on the other side. And I brought two examples. In Kosovo in 1999, the US policy, the NATO policy, but I think it was President Clinton's order, 0 casualties, no risk whatsoever to the American pilots. So they didn't issue early warnings, and they bombed from high latitude. By comparison, I brought the example of the Israeli way of fighting in Gaza, in which Israel did risk its soldiers to some extent. But I think that morally, the Israeli way is more justified because at the end of the day, unfortunately, you kill innocent babies on the other side. So it's a very delicate equation, but I think, and I do agree with Professor Waltzer's argument, that in order to enjoy the so-called collateral damage provision, you have to risk, at least to some extent, your own soldiers.
Thank you. This goes back to what you said about incentives for transgression today. I understood most of your argument except for one of them. You mentioned how an incentive to transgress is that there's only a proportionality of response, so the aggressor wouldn't be punished too severely. There are no effective reparations. The Saddam Hussein is the exception to the rule. And you also said something about territories, and I just couldn't follow your logic. You mentioned that territories used to be kept by the aggressor, and today they have to be given.
No, it's the other way around. If you are in self-defense, in the old days, one of the punitive tools against an aggressor was to take territorial prizes. You annex his territories. But nowadays, under the prevailing rule, annexation of territories is not allowed anymore, even though you are on the defensive side. So when, for example, when the United States or the coalition forces won the Iraqi war, they held many responsible vis-a-vis the domestic population. The same treatment is being given to Israel. So you cannot, under the formal prevailing rules, you are not allowed to have any territorial prizes, even though you are a defensive side. And even though you defend in a legitimate self-defense. Because you are not going to lose almost anything, and you are not losing your own land, even though that you are aggressor and transgressor. Because at the end of the day, even though the defensive side took your territories, whether it's Lebanon or Gaza or the West Bank, at the end of the day, or Sinai Peninsula, you have to return it back under prevailing rules. So if the aggressor is not going to lose, he has an incentive to attack. He has only upper side, and there is no downside to his aggression. That's the main argument of this segment of the argument.
One last question, and then we're going to have to move on. Yes.
I was curious about how you think your arguments would apply to an area of warfare that I'm interested in, which is I'm interested in the area of cyber warfare, and in two ways. One is you talk about the rules and how it apply, but also I heard it mentioned, I think in your bio, that you deal with training, and I know that the Israeli Army has a couple of units which talk about Haaretz dealing with cyber issues, and I was curious how you think the ethics of war could be taught to these units, or how are they being taught to these units?
The answer is that I really don't know. First of all, when it comes to cyber, there is a threshold. In my age, you have to talk to my kids about all those cyber affairs. I know how to use Word and Excel, and that's it. But I don't know. You're absolutely right that a cyber war is some kind of a new warfare. And there should be some ethical standards regarding this war. But I have to admit, I don't know. I'm a combat soldier, not a high-tech professional.